Hi guys, it's Kathy. I hope you're doing well. I got an interesting one for today, but it doesn't have a verdict yet because the judge has to think about it. And I have an update. I don't know if I should say it now. I'll say it now and I'll say it later. You guys here now are going to hear it later because there's only 10 of you here now, and everyone's going to want to know later, but you also want to know right now. Like, you can't wait till later to find out what's going to happen to dementia guy in the wheelchair. Josh found a verdict yesterday. Oh, Ralphie boy lost. He lost. They are not going to grant him a continuance or anything. He is scheduled in, today's the 20th. 16 more days, I think. 17 more days. Now, he's going to be executed in 17 more days-ish, something like that. There's still one more chance for him. The Supreme Court. He has something in the Supreme Court. I do not believe they have a legal reason to overturn anything the judges have already ruled. They need a legal reason to do it. So, I mean, it's not going to be televised. And if it was, it's probably not something I would show. It's definitely, absolutely, definitely not something I would show. But, at least Matt will be able to be there if he wants to, I think. I don't know. We have a couple Utahians in here. Kids from Utah. They could be there. Who knows? Who knows? Sneak a camera in. Don't sneak a camera in. I can't play that. I don't want to play that. I just want to sit down with Matt while it happens. I just want to hug Matt while it happens. See, it's okay. It's okay. It's not okay. What happened to him and his family is not okay. It never will be, even after this happens. But okay, so this one we won't have a verdict for. There's no screaming, there's no crying, there's no meltdowns here at all. It's two lawyers. It's banks. It's a bank versus a class action and a judge. And I think it's pretty interesting. Here we go, Georgia.
For the delay there, folks. It took me a moment to get this thing all warmed up and booted up. Court calls at this time position number 3 on our motion calendar, case number 2025V-0034-CMJ. Cindy McDaniel, that's you, ma'am, versus Community Bank of Johnson County. I'll note for the record that the plaintiff, Cindy McDaniel, is present, seated at the council table.
No, she's not. Anyway, if he's saying Cindy, just so you know, this is not Cindy. Why do I say that? Because this is the mason jar court, okay? And she looks a lot like Cindy, right? The wife who's in the witness box. Her name isn't Cindy, right? I really think it's Cindy. I really think it is. So this is not her. This is not them. We don't get to watch them today.
With her attorney, Mr. Kapler, is that correct?
Judge, other way around. I represent Community Bank. This is my co-counsel, Michelle.
Oh, I'm sorry. I'm looking in the wrong direction. All right, very good. I'm sorry. What's your name?
Michelle Najim.
There we go. All right, you're listed on here. And I thank you for correcting me here. All right, let me start over then. I have the plaintiff is Cindy McDaniel, and her attorneys are here seated at council table. You, Mr. Alonzo.
Mr. Alonzo.
And I'm sorry, I didn't write down your name.
Mr. Schubert.
And they are present seated at the council table. Mr. Kapler and Miss Najim are
Yep.
here representing the defendant, Community Bank of Johnson County. This matter appears on my calendar today for oral argument on the defendant's motion to dismiss. So far, am I correct, Mr. Kepler?
Sounds great, Judge.
Excellent. I'll note for the record that the court reporter is present. We want this matter reported under the rule. Is that correct, Mr. Kepler?
We do, yes, Judge.
All right, very good. So ordered. Both sides ready to proceed?
We're ready.
All right, Mr. Kepler, you have the floor. You may proceed, sir.
Thank you, Judge. And if I may approach, I know you're trying to go paperless, but I got some paper for you.
All right. Thank you, sir.
So, Judge, good morning.
Oh, Letus. That's what happens when you get old. None of us can drink without it dribbling. Welcome to your 30s.
My name is Aaron Kapler. I represent Community Bank of Johnson County, which of course is a division of the State Bank of Cochran. Jackie Bowen, the president and CEO of the bank, is in the courtroom, and so is Angie Carmen, the chief financial officer. State Bank of Cochran first got its charter in 1921. It opened its doors in 1922. And so for the century since then until now, the community bank has provided banking and financial services to this community. And it has done so with respect, honor, and in compliance with all laws and all agreements it reaches with its customers. Without so much as a notice, a demand letter, a phone call, or anything of the sort, State Bank gets served with a putative class action complaint brought by a consumer who is not in the courtroom. And this class action complaint, Judge, is very much like many other class action complaints brought across the country and in Georgia. And they ought to be dismissed with prejudice. And I'm going to tell you why. First, I'm going to explain to you what these claims are generally about, how they get brought, who brings them, how the banks have defended them. Then I'm going to switch gears to this specific case, the contract at issue, the claims at issue. And I'm going to give you a little preview of plaintiff's counsel's arguments that I expect he's going to make and why they are without merit. So first, going back to generally, it's been about a decade or so, Judge, maybe a little bit longer, maybe a little bit less, when plaintiff's lawyers began suing banks and credit unions for overdraft fees. And they typically started with the big banks, the Wells Fargos, the Banks of America, things like that. And they know, just like most people know, that when big international institutions in some cases get sued on class actions, they don't typically litigate on the merits. And the reason, of course, is the exposure is too high, right? If you're a $1 trillion asset institution, $1 billion here or there is nothing for those institutions. And so as these cases go, they begin with these national major institutions. They've winded it down to regional, smaller financial institutions. And now they are targeting community banks and community credit unions. And they're doing so in Georgia and many other states across the country. They're also typically brought by consortiums of lawyers. And these lawyers are the same often. In fact, my friends on the other side, I have multiple cases with them. And they will likely tell you about some of those other cases I've had with them. And we'll get to that in a little bit. And typically what they do is they solicit these consumers on websites to bring these claims. And they bring basically the same boilerplate complaint. They just style it as a putative class action against all of the institutions. They might change a word here or there, but it's basically the same. And this complaint is basically the same. It starts with these generalized allegations of federal regulators being critical of these practices. That's irrelevant. Notably here, the plaintiff isn't the FDIC or some other federal regulator, it's the plaintiff. So they start with these generalized allegations, and then they make these other allegations in the complaint that, frankly, Judge, are false. And you can see that they're false because all you need to do is look at the contract that they attach to the complaint, and you see it's inconsistent with the factual allegations. So, of course, on a motion to dismiss, well-pled facts are deemed to be true. That's the rules, 12b-6. But if there are exhibits, like here, contradict those allegations, you don't need to just take their allegations at face value. You can look at the contract. And in here, that's what this court ought to do. So going back then to this complaint, It was filed and it brought basically 3 claims. Breach of contract. And the first type of breach of contract is what I call available versus ledger. They sometimes call it something differently. But the idea is this. You have $100 in your checking account. You take your debit card and you swipe it at Longhorn and you tip $60. Total transaction is $60. Then you go to the grocery store and spend $50. Well, before those transactions post, it takes some time to go through the system. Before they post, you've already spent your $100 in your checking account, although it has not yet posted. And because of that, your available balance that's in your account drops to a negative, and the contract allows for the assessment of an overdraft fee. Okay, very common practice. In fact, it's nearly universal. That was their first type of claim that they brought. Well, Judge, the contract expressly, unambiguously explains that. So in response to our motion to dismiss, they withdraw that claim. Now, interestingly, they don't amend their complaint to drop it. They put a footnote on the first page of their response to the motion to dismiss saying they withdraw it. Well, Judge, that claim is entirely without merit. Their footnote is insufficient. They've abandoned it. You should dismiss it with prejudice. The second type of claim they bring, and that's really what we're here for, although the other claims are important as well. The second type of claim is called, I call it an NSF retry. They might call it something different, but the essence of it is, Judge, is that when you, for instance, make an online transaction, you go to, in this case, the plaintiff went to Georgia Lottery, and she authorized a payment, according to her complaint, to Georgia Lottery for an amount of money, I guess buying lottery tickets online. I didn't know you could do that, but evidently you can. Well, she didn't have enough money in her account when she bought those lottery tickets. So by the time GeorgiaLottery.com submits the payment to the bank says, hey, there ain't enough money in her account. Insufficient funds. Assesses a fee, not sufficient funds. Well, the contract contemplates that sometimes when that happens, the merchant or the consumer, doesn't really matter who, resubmits that. And if you think about it, it makes perfect sense why. When she went online and bought those lottery tickets, Georgia Lottery gave them her lottery tickets based on the promise that she made to them that when she clicked pay, she had the money in her account. Well, she didn't. So what the terms and conditions of those websites always say, and importantly, what the contract in this case says, and what NACHA rules, NACHA, I'll tell you what that means. It's the rules that govern ACH payments. It's a National Automated Clearinghouse Association. They govern these payments. What those rules say, Judge, is that when somebody is promised payment in exchange for services or goods, in this case, Georgia Lottery, and that person doesn't have enough money in their account and the bank says, whoa, wait a second, she don't have enough money in her account, they're allowed to resubmit it. Makes sense. They gave something in exchange for a promise that they didn't get. So the rules say they're allowed to resubmit it to the bank. And the contract says, well, if the bank gets that retry from the merchant and you still don't have enough money in your account, well, you get assessed another fee. Because that's what the contract says. And that's what makes perfect sense. And we're going to talk about how this contract says it and why it's clear and unambiguous and why it shows the actions are allowed. So that claim is still in the case. They haven't voluntarily withdrawn it, although they should have. They haven't. They also have a claim for the breach of the implied duty of good faith and fair dealing, which of course Georgia law imposes on all contracts. Well, Judge, when the contract claim fails, that claim fails too, right? I mean, that's black letter Georgia law. The next claim they have is unjust enrichment. Well, Judge, as you know, unjust enrichment is only a claim when there is no contract. Well, interestingly, in this case, the plaintiff alleges that she has a contract. She has a checking account with the defendant, which was governed by the contract. That's paragraph 13 of her complaint. Well, Judge, if you look at paragraph 13 of our answer, guess what it says? Admitted. Nobody in this case contests the fact that this relationship is governed by the contract that's attached to their complaint. Nobody disputes it. We don't dispute it. They don't dispute it. There's not an allegation that the contract is void or some other reason why the contract doesn't exist. Everybody agrees it's governed by the contract and it's enforceable. And because of that, Judge, the unjust enrichment claim also fails and it ought to be dismissed. So let's go back to the NSF retry, because I think that's really important. And all we need to do is let's look at the complaint allegations, and then let's look at what the contract itself says. Because as the court knows in Georgia, contracts mean what they say, and they say what they mean. If they're unambiguous, then you enforce it as it's written. If it is ambiguous, and they might try to argue that, it's not. When you look at it, you can see it's not. They might argue that it's ambiguous. But even if it's ambiguous, the next step is, can you determine, based on the language of the contract, what it means? If you can, then you enforce it as it means. And then if you can't, then potentially the motion to dismiss ought to be denied. So if we go to the contract, Judge, and I gave you a little one-page primer in your binder, and I gave a copy to my friends across the aisle here, plaintiff's allegations versus facts. So if you look at paragraph 33 of their complaint, they allege defendant and its customers never agreed that defendant could assess multiple fees for a single check, in-person withdrawal, or other electronic item with the consumer has presented the item for payment once. I put sick there and I even read it weird because I think there was a typo. So let's look at what the contract says. And that's at the very bottom of that one-page primer I gave the court. And I bolded it. It's on page 5 of Exhibit A attached to their complaint. It wasn't attached to our answer, their complaint. Quote, be aware that such an item or payment may be presented multiple times and that we do not monitor or control the number of times a transaction is presented for payment. Period. You agree that we may charge you an NSF fee for each time a payment is presented if the amount of money available in your account is not sufficient to cover the payment, regardless of the number of times the payment is presented.
Whoa. Did I sign something like that? Did I sign something like that? Regardless of the amount of times they try to swipe it? Try again. I could have like $2,000 in fees in just 10 minutes flat. Did we all sign something like that? We did, didn't we? Where's Big Tiff Dog when we need it? All right, that's fine.
So paragraph 33 is directly contradicted by Exhibit A to their own complaint. It begs the question, did they even read the contract before they attached it to their complaint? But that's not the only instance of self-contradictory language. Paragraph 34 of plaintiffs allege, quote, the contract provides on such an authorization, actually promises the opposite. Defendant may charge at most a fee on an item that the customer has only presented for payment once. Judge, that's just false. The language of the contract directly contradicts that allegation.
Thank you, Monica. Thank you.
Those are the allegations, Judge, they're using to defend against the motion to dismiss. And then in the response brief on page 2, remember page 1 had the footnote where they voluntarily withdrew the other claim. Page 2, they say, quote, defendant does not and cannot identify any language, and that emphasis was actually in the original document, in the contract that unambiguously permits its multiple fee practice. Well, Judge, the contract expressly permits the multiple fee practice by its own plain and unambiguous express language.
Okay. So we've heard enough so far that we can make our decision now, right? we can tell everybody who's guilty or innocent. So we have these crooks over here. These crooks are the banks. And when you have no money, they're going to charge you fees for that. Lots of fees when you're broke. You get a lot of fees. Then you get these crooks over here. Now, these crooks over here, they just blast out hundreds and hundreds and hundreds of class action lawsuits, hoping that they'll just get quick payouts from these crooks right here, because these crooks right here don't want to bother with these lawsuits. They're bad for business. So a lot of them just pay these crooks over here money. So we should pick a crook to go behind on this one. I don't like crooks that try to get money for no reason. I don't like people who pretend they're injured to get money. And, no one came to them and said, I'm injured. They put ads out that said, you're injured, you should call me. So, and these crooks kick you when you're down. I don't know which side to pick now. I thought I could pick one. I'm going to pick this one because these guys are crooks, but their crookery is right in front of our faces. We sign it. We sign up for it. We say, yes, just charge me whatever you want when I'm broke. It's fine. These crooks go out and find ways just to get money. They're not trying to solve a specific problem. They're just creating a whole bunch of class action lawsuits.
So not only did we actually identify the language, we pointed to it multiple times, and they're still pressing forward as if the language doesn't exist in the own document they attached to their own complaint. So you're probably wondering, what are they going to argue? How do they get around the plain language of the unambiguous contract? Remember, contracts in Georgia don't need magic words, right? You don't need to have a special word to mean different things. It just says what it says. It means what it says. And you don't need to try to make things special in order to be enforceable. And this language is plain and unambiguous. So here's what they're going to argue, very likely. They're probably going to argue, Judge, that there are trial courts across the country that have denied motions to dismiss of these claims. And Judge, there have been trial courts across the country that have denied motions to dismiss of these claims. They're probably even going to argue that I have been involved in some of those cases where motions to dismiss have been denied. And that's also true. I have had motions to dismiss these types of claims denied. Perfectly true. I hope they also tell you, though, Judge, in addition to the dozens of cases where motions to dismiss have been denied, I hope they tell you about the ones where the motions to dismiss have been granted. You see, when you go through the cases, there are very little, if any, appellate courts that have looked at these. And when you think about it, it makes sense why. Because, Judge, a denial of a motion to dismiss is very rarely appealed, because you got to get a certificate of immediate review. The Court of Appeal has to take it up, which they rarely do on a motion to dismiss. So very rarely are you going to have an appellate case reviewing a denial of a motion to dismiss. And do you know why there's not a bunch of appellate cases reviewing grants of motions to dismiss? Because they don't take them up. Because as soon as they start creating case law and common law where these things are granted on reported appellate decisions, their cottage industry is destroyed because they can't sustain it. The only way they can sustain it is by referring to trial courts that, of course, are not binding on this court, sometimes aren't even persuasive on this court, but trial courts that are looking at different contracts between different parties. So every one of those cases that they talk about where a trial court denied a motion to dismiss, the critical question is, was it this contract between a plaintiff and State Bank of Cochran? And the answer to that question, Judge, is no. There are no courts that have looked at this contract with the community bank and State Bank of Cochran that have found this contract to be ambiguous. There are no courts that have denied a motion to dismiss. with this contract, with this plain and unambiguous language. Now, I hope they tell you about the Trent case, for instance, which came out of Kentucky a couple months ago. A trial court in Kentucky dismissed a retry NSF fee on language similar to this one. They did. I'm not harping on it because I don't need to. The language controls. This language controls. But I hope they tell you about that one when they tell you about all the other ones that have been denied. I hope they tell you about the Lambert case out of Virginia that also dismissed a retry claim under similar circumstances when they're telling you about all the other trial courts that have denied them. I hope they do. The last thing I think they're going to argue is, after they rely on other state trial courts across the country, some federal trial courts across the country, I think the other thing they're going to argue, Judge, is that the language is ambiguous. I think they're going to say two types of ambiguities, neither of which are persuasive or controlling. I think they're going to say that this contract doesn't allow a merchant to submit a payment. And because the language doesn't say a merchant may resubmit the payment, that the contract's ambiguous and it's unenforceable, or it means what they say it means. But what the contract actually says, it just says when an item or payment is presented. It doesn't say by whom, because it doesn't matter. If the contract said only the customer may submit a payment, then okay, maybe they have an argument. Or if the contract said only a merchant may submit a payment, maybe they have an argument. But of course, that's not how it works. The contract says when each time a payment is presented, if the amount of money available in your account is not sufficient to cover the payment, regardless of the number of times the payment is presented. And Judge, I'm sure your experience is the same as mine and basically every other customer who's ever done an ACH payment or written a check or swiped a credit card. I've never taken a check and then paid something with it and then drove it to the bank and said, hey, can you cash this for me? And then draw the money back to the merchant. Of course, that's not how it works. The merchant always submits the payment because they're the ones delivering the goods or delivering the services. The last argument they make, and I don't know if they're going to.
They probably won't, because you just made it for him, sir. All right, Linus is a little young for this, but I wonder if she knows about it. You guys, when she said she's going to go to the dentist, y'all probably just bleeped it in your head for just a second or longer. Linus, you have to listen to something. You have to listen to Bill Cosby going to the dentist. I know, but it was very funny. I know. But that skit was very funny. It was freaking hilarious. Linus, if you haven't heard it yet, you're going to be in tears by the time you get to the end of it. I know. But just because that doesn't mean that wasn't funny. It was freaking hilarious. It was unbelievably hilarious. Bill Cosby, the dentist. They have to have it somewhere on YouTube. You have to go. You have to listen to it. I'm looking for goats. I was looking for a goat for my backyard. Instead, I had to do it myself. I live in Lancaster. How can there not be goats to rent? We have goats everywhere. My best friend rented a house. 30 goats came with it. And there was this little tiny shed out back. A tiny little shed out back. I can't describe to you how tiny this shed was. And every night, all 30 goats would just go into this little tiny shed, just piled on top of each other. They didn't have to go into the shed. That's where they went. And every morning, 30 goats just all came out of this tiny little shed. Linus, you're going to cry. I'm crying for you right now because it's so funny.
But they may say, well, the word item is ambiguous. And so we don't know, the plaintiff didn't know when she made those Georgia Lottery purchases with insufficient money. She didn't know that was an item that she was creating. Maybe they argue that. Or maybe they say the word payment is ambiguous, which again, it's not. But here's how we know they don't really think that, Judge. Because again, you look at the complaint and the allegations of the complaint to understand their understanding of the contract. If they're right that this language is ambiguous, and again, I don't think it is. If they're right, it's ambiguous, you look to the language of the contract and the party's understanding to understand the ambiguity. Well, here's how we know there's not a true misunderstanding or confusion about the word item. Because on paragraph 45 of their complaint, plaintiff alleges that she was charged multiple fees on items. If she doesn't know what an item is, why would she allege she was charged a fee on an item? In paragraph 37, she alleges on March 5, 2024, plaintiff attempted a payment. So to the extent they try to argue to you, Judge, that the word item is ambiguous or the word payment is ambiguous, you need look no further than their own complaint to see that they understand exactly what those terms mean. And you need to look no further than the document itself, the contract that, of course, controls this controversy. Because on my little one-page primer I gave you, Judge, I also quoted payment types. The contract says payment types, some but not necessarily all of the ways that you can access funds in your account include debit card transactions, automated clearinghouse, ACH transactions, and check transactions. All these payment types. So when the contract says that we may charge you an NSF fee for each time a payment is presented if the amount of money available is not sufficient to cover the payment, regardless of the number of times the payment is presented, then that necessarily means, by the own plain language of the contract, that debit card transactions, ACH transactions, and check transactions. So, Judge, I would like to reserve a few minutes for rebuttal, but thank you for your time. I urge the court to dismiss the case.
All right. Thank you, Mr. Kepler. And who will be presenting it? You, sir?
All right. How do we feel about that crook? How do we feel about what he said? I don't know. But now we're going to hear from the other crooks. Now, I didn't hear the other crooks. I heard the first crook when I was getting this together, but I didn't hear the second crook. So here we go.
This is Mr. Schubert for plaintiff.
All right. Let me get to your reply. Give me just a moment.
Go to Discord, people. Go to Discord. There's so much there. It's free.
Before I forget it, it's got nothing to do with the motion, but I know there's been a lot of pro hac VC applications, and I think I signed one.
Yes, you signed
that was
mine,
for you. It
Jerry.
was yours.
Yes.
That's what I thought. All right. I can't pull that one up. Let me make sure I have that. All right. You may proceed, sir.
Thank you, Judge. It's an honor to be here today. There's a lot of folks in the courtroom. I'll be quick. Let's start with what I agree with Mr. Kapler on, which is that the court needs to read the contract and interpret that according to Georgia law. Judge, the court should deny the motion to dismiss. The complaint at this point challenges one fee practice. That's the assessment of $30 fees on the same item that the account holder only presented once. So what's happening here is you have folks at the bank, okay, who are getting $60 or $90 in fees on the same item, okay? And I'm going to argue to you today that practice is not clearly and unambiguously permitted by the bank's contract. Your Honor, the burden is on the bank to show that the contract is clear. In Georgia, the complaint need only contain a short and plain statement of the claim, showing that the pleader is entitled to relief. We've done that. We have to give the defendant fair notice of the nature of the claim and a fair opportunity to frame a responsive pleading. Mr. Kapler's had that. The bank has had that. And the motion should not be granted, the motion to dismiss should not be granted, unless the averments in the complaint disclose with certainty that the plaintiff would not be entitled to relief under any set of facts, which could be proved in support of his claim. These claims have been brought in Georgia. Plaintiffs have survived motions to dismiss these claims. Motions to dismiss have been brought in other jurisdictions.
This is not a National Chase Wells Fargo bank. This is a small, bank in Georgia. They said the name, but I think it's the city, and I can't remember I can't remember the name of the bank.
Similar language, and those motions to dismiss have been denied as well. And I'd like to point out a few of those for the court. So, Judge, this is a contract claim. And the question is whether this contract's ambiguous. The contract is ambiguous. It means that the contract is reasonably susceptible to more than one reasonable interpretation. And so therefore the court should deny the motion to dismiss if it in fact finds the contract to be ambiguous. And in Georgia, just to be clear, the case law states that ambiguity exists when a contract is uncertain of meaning, duplicitous and indistinct, or when a word or phrase may be fairly understood in more than one way. And importantly, where the construction of a contract is doubtful, it has to be construed most strongly against the drafter. That's the bank here. It's the responsibility of the bank to draft a contract that clearly explains how a consumer who is only presented an item once can be assessed up to $90 in fees on the item. Your Honor, we've met the Georgia pleading standard. We've cited the contract language that we allege has been breached in paragraphs 26 through 29 of the complaint. We've alleged multiple dates and examples of Ms. McDaniel being assessed multiple fees on the same item. So what's the question? The question here is, can words or phrases in the contract be fairly understood in more than one way? Let's look at page 5 of the contract. That's Exhibit A. So it starts by stating, if an item, I'm on the bottom of page 5, second to last paragraph. The paragraph entitled non-sufficient funds, open paren, NSF, close paren, fees. Okay. If an item drafted by you, who is you here? The consumer. If an item drafted by you, such as a check or a transaction you set up, who sets up the transaction? The consumer. Such as a pre-authorized transfer is presented for payment in an amount that is more than the amount of money available in your account, and we decide not to pay the item or transaction, you agree that we can charge you an NSF fee for returning the payment. Okay? Be aware that such an item or payment may be presented multiple times and that we do not monitor or control the number of times a transaction is presented for payment. You agree that we may charge you an NSF fee each time a payment is presented if the amount of money available in your account is not sufficient to cover the payment, regardless of the number of times the payment is presented. Okay, the last sentence is the key sentence. Each time a payment is presented. The question before the court is whether that language is clear. Who presents the payment? Reasonable consumers understand that they're the ones setting up the transaction. They're the ones drafting the item. Okay? They could read this and reasonably understand that they would be the one presenting the payment. How does this actually work? Third-party merchants have a right under the NACHA rules, which I hesitate to bring out because it's wildly outside of the pleadings, like a lot of things that we heard in defendant's opening argument. But that gives the merchant the right to represent the payment. But the question is, does the bank have the contractual right to assess up to $90 in fees on an item that the consumer has only presented once when the contract doesn't say that consumers present items? And it doesn't say that third-party merchants present items. It doesn't say either. It's unclear. That ambiguity needs to be construed against the drafter under Georgia law. I want to note one other thing. Exhibit B, the fee schedule. Okay, the fee schedule, it's Exhibit B to the complaint. It's got a $30 line item for overdraft fee, which is an item paid. And it's got a $30 line item for returned item fee, which is an item returned / not paid. This language about an item or a payment being presented, okay, it appears in both the overdraft fee line item and the returned item fee line item. Well, this is another example of the bank's practice not matching the contract, because an overdraft fee is assessed when the item is paid. That's the end of that story. There's no representment. It's paid into overdraft. So you have an example here of contract language that is not written to form an agreement with consumers about how these practices actually work. It's boilerplate language that's thrown into the contract that confuses folks who don't actually agree to this practice. There are a few recent cases out of state where similar contract language to the language at issue here. In those cases, the courts denied the motion to dismiss. I just want to point you to the Kimball case, which was attachment 4 to our notice of filing, which came with the response to the motion to dismiss, and the Murray case, attachment 5. In both those cases, the court found that it was reasonable to understand similar contract language to mean that the consumer was the one presenting the payment. In other words, the contract was just ambiguous as to whether third-party merchants or consumers presented the payment. Your Honor, there was discussion of paragraph 45 of our complaint that somehow the fact that we used the word item in that allegation was fatal. Mr. Kapler didn't finish the sentence. Its defendant also charged plaintiff multiple fees on an item that plaintiff only presented for payment once. That allegation and all the others should be taken as true on the motion to dismiss. We've brought claims for breach of the good faith of the duty of good faith and fair dealing, which is implied in every contract. That claim rises or falls with the contract claim. On unjust enrichment, we're here at the pleading stage. Rule 8 allows us to plead in the alternative. We've done that here. And I would also note that even in the existence of an express contract, if that contract does not include a specific provision that addresses the practice at issue, I would argue that there is room for an extra contractual remedy there. So with that, I would ask the court to deny the motion to dismiss. Thank you.
Thank you, Mr. Schubert. Rebuttal, Mr. Kaplan?
Yes, Judge. So I was a little disappointed my friend did not reference the cases granting the motions to dismiss. I guess I'm not entirely surprised. But again, March 2025, Kentucky, Trent versus Members Heritage Credit Union, court dismissed multiple OD fees on a single transaction claim, very similar to this one. I have a copy for the court. It doesn't really matter, Judge, because it's not Georgia law. It ain't this contract. But if you want to look at other states' cases, I have some for you too.
I'll look at it, sure.
Thank you.
Thank you, sir.
Yes, sir.
So on Trent, page 8, the contract says your account may be subject to a fee for each item regardless of whether we pay or return the item. We may charge a fee each time an item is submitted or resubmitted for payment. Therefore, you may be assessed more than one fee as a result of a returned item and resubmission of returned item. And the court there found that that language clearly and unambiguously authorized the assessment of NSF fees when the items are represented for payment, just like the contract does here. So his argument, as best I could tell, because he admits they're an item, the contract says, quote, "Be aware that such an item may be presented multiple times, and that we do not monitor or control the number of items a transaction is presented for payment, and that you agree that we may charge you an NSF fee for each time a payment is presented, regardless of the number of times the payment is presented."
You already said that, dude. Move on.
That's what the contract says. That language is unambiguous and very clear. His argument
You already said that, dude. Move on.
That because it doesn't say the merchant presents it each time, it's somehow ambiguous. It doesn't need to say that. It just says when it's presented. It can be presented by the plaintiff, the merchant, which is how things actually work in the banking industry, or I guess some other way. It doesn't really matter because the contract isn't narrowed like they want it to be. They're essentially wanting this contract to say something it doesn't say. They want it to say that only if a consumer submits an item for repayment may you charge multiple NSF fees. That's what they want it to say, but that's not what it says. It just says when the item is resubmitted for payment. And in fact, if you take their argument to the logical conclusion, the entire banking industry collapses. That only the plaintiff, is she going to now have a payment processor at her desk when she submits a payment? Is she going to connect to the Federal Reserve and transfer monies between banks? I mean, that's an insane argument. And of course, it's not necessary because the language doesn't require that. So for the court's convenience, and I gave a copy to my friend across the aisle, in the front part of your binder, Judge, is a proposed order granting the motion to dismiss. And I would ask the court to review that proposed order, and I believe you'll find it to be particularly well-reasoned, very straightforward, and I'd ask the court to enter that final order and grant our motion to dismiss. Thank you very much.
I thank you both. Well, as you can plainly see, I've got a busy day ahead of me. I'm not inclined and not my typical practice to just shoot from the hip. This is my first time looking at this. I was trying to get ready and looked at some of it yesterday, but I am not prepared to issue a ruling from the bench. And I generally will have my staff attorney and my staff who are watching. I am streaming, by the way, and that as soon as I get back, we will start going over this. And I usually, if I have any follow-ups or instructions, do that by email, someone from my office. But that's it for today. I'll let you all know.
Thank you.
All right, you're all excused. Thank you. Thank you, Judge.
I'm gonna watch out for that because I am highly interested on which criminal is gonna win there and if I'm gonna start my own lawsuit. Only because I have children. And my daughter racked up not Temu, Emu. There's this website. No, it's IMVU. There's this website, and when she was a little girl, she got my card, and she ordered all kinds of stuff, little digital shirts, skirts, boots, a car, a house, all for her little avatar on IMVU. So nothing real. I couldn't hold any of it. And she didn't know how much was in my account. She overdrew, and everything she charged, I got a fee for every single thing. There were things that were only like 2 or 3 cents that she charged, and I got a $40 fee for it. My account was like $1,400 negative by the time she stopped her spending spree. And there wasn't, I don't even remember how much was in there, but like I remember one of the skirts for like 50 cents. It was less than $1. And IMVU tried over and over and over again to charge it when there was nothing in my account anymore because they've already taken it all. And every time they did it, it was $40, $40, $40, $40, just for this 50-cent little skirt on a little avatar. When I found out, I put my daughter in a car and we drove to a Mexican restaurant here with humongous margaritas. I mean, the margaritas were this big. And I sat her down and I'm like, no, no, don't talk to me. I ordered my margarita. I took like 3 sips of my margarita and I said, listen, I brought you here in public so I would not kill you. But we need to talk. But we're talking here in public so that I do not kill you. I loved that margarita. That was delicious. Okay. Now we're going to go to, speaking of kids, there's no answer for this next one either. He has to ponder it. Here it is. Here it is.
After lunch, because this is probably going to take about an hour, and then we'll take
It
a lunch
doesn't.
break, and we'll start back at 1:30.
It doesn't take an hour. Maybe it does. I don't know. Drink margaritas? Yeah. Go
Well,
drink
30
strawberry
minutes each
margaritas.
side.
I'm going to do my best.
Right. Hold on one second.
Dodge. Where is Dodge?
Sarah, are you gonna object to any of the certified?
You know who was not invited to the Mexican restaurant to yell at this little girl who just spent a lot of money by accident, but not really by accident? My husband was not invited because he was very angry. And here's the little girl, she didn't do it on purpose. It's not like she on purpose just stole all of our money. Yeah, she knew what she was doing was wrong, but the skirt was only 50 cents. So she thought, well, 50 cents, not a big deal. She didn't realize how many items she was buying at 50 cents. So he was not invited to come. I didn't need help parenting at that moment in time from someone who was just gonna trash this little girl. I trashed her. I did. I was pretty mad, but I didn't trash her. I didn't destroy her. I just let her know she's not allowed to do that anymore. And she already knew. She already knew she wasn't allowed to do that anymore. As soon as we said the number at the end, her face was like, oh, she knew. But yeah, it was just me and her. That she is. And she doesn't play IMVU anymore.
Have a seat, pull that microphone down, give it a thump. Let's make sure it's working.
He loves
Very good.
that.
All right, Miss-
Listen, this judge loves thumping those microphones. this judge will have this woman right here in the middle of dockets. Hey, go thump the go thump that microphone like over here. Make sure it's working. I need you to make sure it's on. So she'll walk up and she'll start tapping it. He's like, no, you gotta keep tapping. You gotta keep tapping it to make sure it's on. There's absolutely no reason for it, but this judge loves thumping those microphones. It's freaking hilarious. She was like 9, 10, I think.
Ms. Kirkland, you can swear him in and proceed.
Will you raise your right hand? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Will you state your name for the record?
Wesley Neesmith,
How are you employed?
with the Dodge County Sheriff's Office.
All right. Back in July of this year, did you accompany Ms. Mobley and Mr. Cawley to a residence in Dodge County?
Yes, ma'am.
Okay. And were you on duty that day?
Yes, ma'am.
Sorry, this is a temporary custody order hearing for the children that I don't think the dad is involved at all. I think it's mom and her sister, I think. It could be mom and dad's sister, but I don't think so. I think it's mom and her sister. But anyway, this is not a permanent custody hearing. It's a temporary custody hearing. And I just told you there's no verdict, which means, you know, there's not an immediate emergency that needs to be taken care of right now or this child's in trouble. That's not what we're about to.
Are you
July.
in uniform and in a marked patrol unit?
Yes, ma'am.
Okay, what happened when you got to the residence? Where
What's
where
the-
was it? Do you recall?
I do not recall the physical address.
Was it Fountain Road? Does that ring a bell?
Yes, ma'am.
Okay. What did you find when you got there?
Once we knocked on the door to serve the paper from the judge, a 14-year-old male come to the door and advised that he was watching his two younger siblings. And I advised him of the situation. He advised, could he call his mom? And I advised him to please call his mom and have her en route to the address.
Okay. How did the child act?
He was, once I told him everything that was going on, he was very adamant that he did not want to go at first. And then once mom got there, I told her what was going on. And she said that she would be able to calm him down. So that's what we allowed.
Okay. Did mom turn the children over?
Yes.
All right. Did she provide any medications?
An inhaler.
Okay. Did you hear discussions between Miss Mobley and the defendant about medication?
I heard Miss Mobley ask, was there any more medications that the children need to be given?
Okay. Were any others given besides the inhaler?
Not that I've seen.
Okay. How long did it take the defendant to arrive at the home after she was called?
Roughly 10, 15 minutes.
Okay. All right. And what were the children doing?
During the time,
Yes.
they were inside the residence.
Okay. Did the defendant's husband appear?
No.
Okay. Is there any other thing of note going on when you got there that day?
Nothing that I could think of.
Okay.
We just stood by while mom calmed the oldest child down.
All right. I have nothing further. Ms. Riedel may have a few questions.
Good afternoon, Deputy Neesmith. When you went to pick up the children, did mom cause any trouble?
None.
Did you see anything that was disturbing about the home?
We did not enter the residence.
Okay. Did you ask to go into the residence?
No, ma'am, because they come outside to us.
Okay. And did mom comply with with the order that you were given to her?
Yes, ma'am.
Was from her reaction, was it obvious that she knew nothing about this?
At the time, yes. She knew nothing about it. That's why I had the 14-year-old call her. And then once she arrived, we served her with the paper.
And mom was at work when you when she was called, is that correct?
Yes, ma'am.
Okay. Did you see anything that gave you concern about the children as far as the way they looked?
Not to my knowledge, no, ma'am.
Did the children seem to be scared of my client, of their mother?
Not to my knowledge, no, ma'am.
Okay. All right. I don't have anything further. Thank you.
Yes, ma'am.
Anything else, Ms. Kirkland?
No, Your Honor, we'd ask you to be excused and be allowed to return to work.
All right, Deputy Neesmith, you are excused, free to go about your business. Thank you, sir.
Thank y'all.
All right, call your next witness.
Call my client, Your Honor.
Come on up here, man.
Only if you need it. Tell me you need it. Yeah, you can't testify unless you need it clear. I don't know what's going on. Yeah. Yeah, it's fine. All right, will you raise your right hand? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, if you'll sit down, and you're going to need to speak into the microphone because you're very soft-spoken. All right. Will you state your name for the record?
Lucretia Mobley,
And where are you employed?
the United States Postal Service,
How long have you been with the post office?
19 years.
And where do you live?
Lansford Community in Glenwood,
Okay, is that Wheeler County?
Wheeler County,
How long have you been in Wheeler County?
my whole life.
Okay. Now, who is Paige, the defendant? to
She's
you?
my niece.
Okay. And what's the relationship there? Whose child?
My
is she?
oldest brother is her daddy.
Okay. Have you been involved in her life, her whole life?
Yes, ma'am.
Okay. How many children does she have?
She has 3.
And what are their names?
Ty Lee Phillips, Robin Abriella Page Floyd, and then Asa Paxton Lynn Nails.
Okay. How old's Ty?
Ty's 14, fixing to be 15.
And what do y'all call Robin?
BB.
BB. So
BB.
BB is a girl, correct?
She's a girl.
And what year was she born?
She was born in 18.
Okay. And then Asa Paxton is a boy.
A boy.
Correct? And what year was he born?
19.
Okay. Now, how involved have you been in these children's lives?
I was involved in their lives quite a bit until she just left
Okay.
with them.
Have they ever lived with you?
Yes, ma'am. Paige and Ty lived with me years ago, and then she moved out and didn't let me see him for 3 years. And then,
Your Honor, I'm going to ask the court not to consider any testimony that goes back behind the 2022 previous order where Miss Mobley attempted to get custody then.
All right, Your Honor, I'll move forward. I was just trying to give the court a little background, but I don't know if the court remembers or needs refreshing.
Vaguely, I mean, I understand there'll be some overlap, but Ms. Riedel, your objection is well taken and noted. The court will not make any factual determinations about what happened in the previous case. But I understand it's a temporary hearing and there'll be some blurred lines, but we'll get through it. You may proceed, Ms. Kirkland.
All right. In 2022, were you awarded visitation with Paige's children?
yes, ma'am.
Okay. And have you been exercising that visitation?
Yes, ma'am.
Okay. And how often was that?
Once a month and then a week in July.
Okay. Did you begin to get concerned about the children since 2022?
Yes, ma'am.
And let's talk about where they lived since February of 2022. Can you tell the court how many addresses they have had?
6 that I'm aware of.
Okay, let's go over that. Where did she live when
She lived in Milan on Highway 280 whenever the first visitation, which was February the 11th of 2022, when I picked them up, that's where they were.
okay, and that was off Highway 280, is
That's
that
right.
correct? Okay. And where were the children in school then?
They were in Telfair County.
Okay. All right. Then after that, where was the next residence?
She moved close to her uncle's,
Okay, and where
Oh.
was that?
Shady Lane and Helena McCrae,
So that was still Telfair
Telfair
County?
County. Mhm.
Okay. Were the children at some point prior to being enrolled in Telfair in Wheeler County schools?
They did go to Wheeler County for a short amount of time.
Okay. Then after Shady Lane, where did she move?
She moved to Misty Lane in February of 24,
Okay. February 2024, moved to Misty Lane.
Misty Lane,
Children still in Telfair?
Telfair.
Okay. Then from there,
From Misty Lane is when she moved to Baxley
okay. And what
on
was,
Donnie Lane, an apartment.
okay. And how long was she there?
She was there from like August to February maybe of 25.
All right. Do you know why she left Donnie Apartments?
I'm not sure why. She was evicted.
Okay. All right. Then where did she go after Donnie Lane? in
She went to
Baxley?
Tallahassee Street in Hazelhurst.
Okay. Now, when they moved to Baxley, where did the kids go to school?
Baxley, Appling County.
Okay. Then when they moved to Hazelhurst, where did the kids go to school?
She drove them to Appling County.
Okay. How far of a drive was that?
I'm not even sure.
Okay. Then, and all this is, let's see, since February of 24, we started out at Misty Lane, correct, Donnie Lane, then to South Tallahassee and Hazelhurst. Then where is she living now?
Eastman,
Okay, and do you recall that address?
Fountain Lane.
Okay, so since February of
67.
2024, they have lived in 4 different residences.
Since when?
February of 24,
Yes.
2024. Okay,
Of 2025?
2024.
2024.
Okay, so basically 18 months, 4 residences. Is that correct?
That's correct.
All right, and then they've been in Appling County schools, is that right?
Yes, ma'am.
And then they've been moved to Dodge.
They never started Dodge,
Okay. They are in
but she
Wheeler
drove
now.
them from Eastman to Dodge.
or Eastman to?
I mean,
Dodge?
Eastman to Appling County.
Okay. Now, BB, what grade is BB in this year?
She is repeating the first grade.
Why is she repeating based on your understanding?
Low test scores.
Okay. Did she miss a bunch of days?
She missed a
last
lot
year?
of days.
Okay. Your Honor, I'd like to tender plaintiffs 1, which is rental records from Donnie Lane Villas. And copies of everything we intend to introduce have been provided to council.
Well, Your Honor, they were, but they were just provided, this whole stack was just provided this morning, so I haven't exactly had a opportunity to look at everything.
Okay. And then claims 2 is from OW Reynolds, which I believe OW Rents is the Hazelhurst. Are you going to object to one? Your Honor, we made the tender plaintiffs 1. This is a certified copy of occupancy records from Donnie Lane Buildings in Baxter, Georgia.
Any objections, Ruth?
No objection, Your Honor.
Admitted without objection.
You got mine. And then plaintiff's exhibit 2, Your Honor, is certified copies from OW Rents, RENTS, for the Hazelhurst rental property. And let's move on while Ms. Rio's looking at those. Are you concerned about the stability of the children's lives?
Oh, yes, ma'am. They deserve stability.
Okay. Do you have concerns about your niece's husband?
Yes.
Okay, explain those to the court without using hearsay. Has the relationship between you and your niece changed since you married Mr. Milton?
Well, prior to the marriage, whenever I picked him up on Friday at 6 o'clock and took him home on Sunday at 6 o'clock. She had never asked anything. And then all of a sudden, she started asking and then texting me constantly, like, what are they doing? How they doing? But she never did that before. And then when they lived in Baxley, also, when they started changing addresses so much, and I always text her on the day I pick them up, be there at 6 o'clock, thanks. Each time she moved, she's like, okay, now you need to meet me at the sheriff's department. And I'm like, no, because it states that I pick them up from the home, so I'm coming to the home. And I think they were just trying to hide those evictions from me, how many times they moved. And then Christmas of last year when we took him home, he came to the door, hollering at us, telling us to hurry up and leave as we were unloading the Christmas presents.
Okay. Did you actually get to open the presents with the children?
Hey, we do that at my house. This was when we took him home and we were unloading the vehicle, setting the stuff outside the door. And he come out trying to hurry up and leave, see how fast y'all can leave, and started yakking and we just left. I mean, we don't.
All right, Your Honor, we moved to tender plaintiffs 2. This is the certified records from OW Rents LLC.
Any objection, Ms. Ruth?
No, Your Honor.
Admitted without objection.
Are you aware?
Or why is he making faces and talking to me?
I'm sorry.
Why, can he do that?
I have no idea.
I think she's saying Mr. Melton is.
Well, you just focus on this,
Okay,
on this correct.
okay, I'm sorry.
Okay. Now, are you aware that Mr. Melton has a criminal history in the state of Georgia?
Yes, ma'am, I am.
And does that cause you concern?
It causes a lot of concern.
All right. Are you aware that he has been to prison?
Yes, ma'am, I am.
Your Honor, I move to tender plaintiffs 3. These are certified copies of occupancy records from Plains Investments LLC.
Ms. Rita?
No objection.
Admitted.
Okay. Are you aware of what Mr. Melton went to prison for?
When he assaulted which time? The time when he went to prison, when he assaulted the guy?
Okay, so he did go to prison, to your understanding.
That's my understanding.
Okay, and how, do you know how recent that was?
I can't remember.
Okay.
I can't remember.
Was there an incident out of Florida that you became aware of that causes you grave concern?
Oh, that, a lot of concern.
Okay. Were you aware that Mr. Melton has bounced between Florida and Georgia
Yes, ma'am.
for a number of years? And did you become aware of allegations against him regarding sexual abuse
Yes,
of a
ma'am.
child? Okay. And were those in Bradford County?
Bradford
Florida?
County.
Okay. And how old is BB?
BB is 7,
And she's a girl.
and she's a girl.
Okay. How long, do you know how long your niece knew this man before she married him?
Not long.
Okay. Had he been involved in family gatherings? Was he a long-time family friend or relation to the, was he around?
There was not a lot of communication between she and I.
Does the nature of what he was accused of in Florida give you great concern? For him?
Absolutely.
Okay. What has happened since you brought the children to your home? How have they been?
They've been doing, Ty is struggling, of course, because I've not seen him in 4 years. The visitation, I was supposed to be allowed to see him too, but I've not seen him in 4 years.
Okay.
And so, of course, me taking a 14-year-old boy out of the home and bringing him into mine. But the other two are doing well.
Okay. Your Honor, I move to tender plaintiffs for, this is a certified copy of records from Bradford County, Florida, related to Tony Howard Melton Jr., who is the husband of the.
Well, Your Honor, I'm objecting to those records. Now, while under, I guess we keep calling it new rules that are now 10 or 12 years old, police records can be introduced. But these police records are full of hearsay. They are not things that the officers have seen. So I would definitely object to these records.
What are they? Incident?
Yes, Your
Incident
Honor.
report.
They are an
Incident
incident report involving an allegation of sexual abuse by the daughter of one of Mr. Melton's paramours.
Oh, Your Honor, I would like to go forward further to say that this was never, there was never an arrest, there was never any convictions. This is hearsay from a mad person who he saw. So no, I am objecting to those records.
Actually, Your Honor, I believe there was a conviction in that case for lewd and lascivious behavior against a victim less than 12 years old. The certifieds are just not in.
Mm-mm. Well, Your Honor, I've not been provided any records. I really just were provided this whole stack of about 1,000 pages this morning. However, these police reports are not admissible under any rules, under any exception, due to the complete hearsay nature of each of the reports.
All right, well, for today, I'm going to sustain Ms. Riedel's objection, and I will not admit these for today. So P4 is not admitted. All right, you may proceed, Ms. Kirkland.
Now, did Ty have a cell phone when he came to your house?
Yes, ma'am, he did.
And were you okay with that initially?
Initially, yes, I didn't say anything about the cell phone.
Okay.
That was fine.
Did it become a problem?
Yes, ma'am, it did.
Did you take it from him?
I did.
Okay. What happened after you took the phone?
Oh, he was not happy.
Okay. Overall, though, how did his behavior and interaction? with the
It got
family?
better. He interacted with us more
Okay.
because he wasn't on the cell phone constantly.
Did you discover that he had another phone?
Your Honor, I'm going to
recently?
check to
Yes.
hearsay.
How is it
Not
hearsay?
not
I'm
hearsay.
asking her,
I'm
did she
sorry.
discover-
I'm sorry. Leading. Sorry, wrong objection.
Well, we have a very limited amount of time here, and I'm trying to clip this along, Your Honor.
I understand. Well, it is a temporary hearing, so it is leading, but it's a temporary hearing, so I'll sustain the objection.
Okay.
Proceed, Ms. Kirkland.
Do you know if Ty has another phone?
He did have another phone. I just took it also.
Okay. And where did he get that from?
He came back from visitation with it on that Monday.
Okay. And that was after visitation with his mother?
Can I clarify why I took the phone, the first
Yes,
phone?
absolutely.
I took the first phone because I I had a paddle that I used on my teenage kids, and it's sat in my kitchen for 20 years. And Ty come in there one day and he said, what is this? After the first day he was there, he mentioned it. And anyway, so he walked back in there and said, why are you asking me? You know what that is. And then I seen him walking back in there and get it. And he went out the back door and he went and locked himself in the playhouse with the phone. And he was taking it because he said his mother and his Nana Becky wanted him to send pictures of the paddle to him.
Okay. Did you believe he was trying to create a situation where he would be accused of being, or he would accuse you of paddling?
Paddling the little ones, I guess.
Have you paddled any of these children?
No,
Okay.
absolutely
And
not.
is this the phone you took from Ty?
Yes. Mm-hmm. Yes, ma'am.
Have you looked at it?
No, ma'am.
Why'd you take it from him?
Because he was staying up all night on it, and he hid it from me. And he's not asked about it since I took it because he knew he wasn't supposed to have it. So he's not even mentioned that phone at all. It's like it never existed.
Did Paige discuss with you if Ty could have another phone?
No, no, ma'am.
So she just sent the phone with no discussion
Right.
whatsoever. Now, have you been taking the children to counseling?
I've taken Ty. We had to cancel some. I had Bibi and Paxton set up. The counselor messed up on those and set the appointments on a day they wasn't supposed to. So they called, and then I told them I had to wait until after today was over with to see. I didn't set one up because I didn't know what it was doing. And then we also got COVID. So
Okay, so you've had COVID, y'all all had COVID?
we've had COVID last week.
Okay.
She's an outliner because she speaks very fast for someone in Georgia. And she must be psychic because she starts answering the question. This lady, she just said now. She already knows the answer to the next question. She's gonna start talking.
What was the final straw that made you seek the ex parte order?
In June, when I picked Paxton up, he had some pretty bad bruising on his buttocks, and that was my final draw.
I'm gonna approach the witness with plaintiff's 5 if I may. Can you identify these? These are 2 photos. I'm tendering them as one exhibit. Do you recognize those?
Yes, ma'am.
What are those?
That's bruising on Paxton's buttocks and his leg.
Okay. Did you take those photos?
Yes.
Did they fairly and accurately portray the condition he was in when you picked him up?
Oh, no, actually in person they were worse. I couldn't get a good picture to.
Have you changed or altered these photos?
Oh, no,
in any
ma'am.
way? Okay. Your Honor, we move to clear the plaintiff's file.
No objection.
Admitted without objection.
And were you made aware of defects being called because of this?
Yes, ma'am.
Okay. Did defects contact you?
3 weeks later.
Okay. And which counselor have you been taking Ty to?
It's Stepping Stone in Hazelhurst.
Okay. Is it Stepping Stone or Stepping Point?
Stepping Point.
Starting Point, I'm sorry.
Starting point.
Counseling records for Ty. Do you want to maintain custody of these children?
Oh, what's best for these children?
Okay. Ty wants to go home, doesn't he?
Ty wants to go home
Why are you concerned for Ty to go home?
because Ty came to me. I got him July the 22nd, and she told me he did not need any medicine. And when I took him last Monday on the 11th of August to the visitation, the lady comes out with 2 things of medicine that Ty was supposed to be taking. And I asked when I picked him up, did they take any medication? He said no. And he was on Prozac and an intunative for the ADHD, and he had not received any of those since the time that he's been with me until Monday.
And you specifically asked before leaving the home with them that day
Oh, yeah.
if there were
Yeah,
additional
and I
medicines.
just had him the week before for my week in July, and I asked her what had changed from the week whenever I had him, because Paxton and Bibi had, vitamins and iron, and she said they didn't need them no more.
Okay,
Or she told the officer spoke for her. She didn't speak at all.
okay. Let's talk about Paxton. What is Paxton's speech like?
It's pretty low. He's not very verbal. He's getting better. He's doing better.
Okay. Have you started him or plan on starting him with speech
Mhm.
therapy?
I have taken him to a speech therapist. She just texted me yesterday, but I had my first grandbaby yesterday, biological grandbaby born. So I couldn't make it. She wanted me to come at 3:00 yesterday, but I couldn't do it because I was at the hospital. And so the insurance just approved it yesterday. And so I will. He's going to start in school also. They're waiting on me.
You know what absolutely sucks about these hearings with the children? And I understand why, but I would die to hear a little 3-year-old with a Southern accent get on the stand and say anything. Anything. Just talk, sweetie. Just talk. I don't care what you say. Or a 6-year-old with a deep Southern accent. I want to hear that.
Hearing test. And then as soon as he starts there, I'm still going to take him after school too.
Okay. So there are delays there.
Oh, yes.
And to your knowledge, was Paige taking him to any kind of speech therapy?
No, he's receiving it through school twice a week. They did tell me that from Appling County.
But no outside?
None outside of the school.
There would have been nothing during the summer?
Not that I'm aware of.
Do you believe these children are being looked after the way they should be when they're with their mother?
No, I don't.
Has this created a major rift in your family?
Yes.
Okay, explain that to the court.
Has it affected my family?
Mhm.
Yeah,
Yes.
I mean, because you've got 3 kids.
Like your extended family, your siblings, how did they feel about you doing this?
Oh, how do they feel? They see it. They see the kids at my house. They come to my house for the family get-togethers. She's kept these kids from everybody sitting back there. Nobody's gotten to see these kids. And so it's affected them big time in a family way. I mean, they're getting to do experience stuff.
Speaking of family way, I'm missing out. Micah wanted to personally say hi to all of you. Just so you know, Micah said hi. So next time Micah's in here, you have to say hi twice. Because you have to say hi back to him for today. He's doing real life things today. But he did say hi.
Go, be with family, be with people that love them, that's not been able to see them in 4 and 5 years.
Why do you believe she was keeping that from you?
Your Honor, I'm going to object to that.
I'll withdraw the question. Your Honor, I'll tender plaintiff's exhibit 6. This is starting point. The behavioral outreach.
Who
Your Honor,
else?
I'm going to object to those because
Who else wants to see the lawyers get in a fist fight real quick? Just a little one. Just a tiny little one.
I should have been given 24 hours notice of any medical records, and I have not. I just received those this morning.
We sent notice of the subpoena timely, Your Honor.
I'm sorry.
We noticed her of the subpoena that was sent for them.
I was noticed of a subpoena, but I wasn't noticed. I mean, I was not given any notice of the records. And I think the rules state that I would be entitled to a 24-hour notice of any medical records.
Well, it's a temporary hearing, so I'm going to allow it for today. Your objection is noted and noted for the record, Ms. Root.
Thank you, Your Honor.
Has this been difficult for you to do this with your niece being the defendant?
Absolutely.
Okay. Did you want to do this?
No, I'm 51 years old. I had my first grandbaby yesterday. I got 3 other ones. And I didn't really want to start raising kids at 51, but I feel like something needs to be done.
Okay. How have the children's demeanor Or has their demeanor changed since coming to your home?
I think so.
How
Thank
did
you,
they act
Monica.
now
Thank
versus
you,
when you
thank
got
you.
them?
They've calmed down some. It took them a minute to see that they're not just there to just play like they were when they were there on the weekends.
Okay.
But they're doing good.
Are they getting to school on time?
Yes, ma'am.
These are all the schools.
Except during COVID.
And I'm fine with him going, looking back to 22, but when they send the certified,
That's
They
fine.
send
I don't have a
everything.
problem. I get that.
all right, Your Honor, at this point, we tender plaintiff 7, 8, 9, 10, 11, and 12. These are certified copies of the children's school records from the various school systems they've been enrolled in since February.
All right.
Your Honor, I don't have an objection to the records as such. However, I think that the court should not, you can't go back behind the 2022, but I understand when they send records, they send the records all the way back. So
I understand.
for that reason, I don't have an objection to the records as such.
With that limitation, then it
Have you looked at any of the records, any of their school records prior to
I have some.
today? Okay. Were they tardy a lot?
Yes.
Okay. When was that?
Especially when they moved from Hazelhurst to Eastman and they were driving
Okay.
back to,
And where were the kids in school then?
they were in Appling County.
So she was driving from Dodge County to Appling
Appling
County.
County.
How are the kids doing since school started?
They're doing good.
Do they like Wheeler County?
They do. They do. Bibi and Paxton especially, Ty not as much.
All right. Did you become aware that Paxton sees an ENT, an ear, nose, and throat
Yes, I took
specialist?
him I took him last week on the 15th, I think.
Okay. And is that part and parcel of the speech delay as well? Not sure.
He told me he wasn't 100% sure about that because I asked him if he
Your Honor, I'm going
had.
to object to this hearsay.
So you took him to the ENT. You took
I
him to the
did.
ENT. All right. Were you aware that he had missed appointments prior to that?
Yes, ma'am.
And where is this ENT?
I took him to Waycross. They also have an office in Douglas and in Tifton.
It's the same practice though.
Yes, ma'am.
I do love this court. I feel like I can see the town.
Have you also taken them just for a regular checkup?
Yes, ma'am.
And where'd you take them to?
I took him to Dr. Archie in Vidalia.
Okay, and what practice is that?
That's Vidalia Pediatrics.
Or whatever since
Yeah, whatever.
they got a name 10
Yeah.
miles long since they were bought out by
Right.
Meadows.
You know, it's right across from the Piggly Wiggly. You know what I mean?
Is that who they have been regularly seeing?
Since they come in my care, yes, ma'am.
Okay. Your Honor, I moved to tender plaintiffs 13.
This is what?
These are the ENT, the ear, nose, and throat records. Pretty sure.
Your Honor, I have the same objection that I was not given notice.
All right, same ruling. Your objection is noted, but I'll admit them for just today only.
Were you made aware of Mr. Melton being arrested in Eastman recently or in the last few months?
I heard about that.
Okay. Your Honor, we, take that. Here's the thing that Okay. Your Honor, we have plaintiffs 14, which is certified copies of the booking and incident reports involving the defendant's husband.
And Your Honor, I'm going to object to those as well as I did the previous police reports. First of all, they're not, I mean, they say nothing that is of any probative value in this case because it is full of hearsay and which cannot be considered by the court. And the rules do not allow those type of police reports to come in.
Your Honor, it is probative. At least 2 of the children were present during this incident, and this goes to show the kind of household the children have been living in. It goes to the heart of this matter.
Your Honor, it's hearsay. The people that were involved in this incident could have been brought into court or could have written affidavits. That didn't happen.
What are the numbers again? 14?
This is 14.
14.
Again,
They're
Your
incident
Honor.
reports?
Yes, Your Honor.
Well, I'm going to sustain the objection. They will not be admitted for hearsay.
We do have a booking report we can tender separately that does not contain hearsay. All right. Your Honor, we'll submit this as 15. Plain as 15, this is the booking report. It does not contain any hearsay.
Ms. Riedel?
Your Honor, I don't have an objection to it. It just goes to, there's not been any conviction on that, but no objection.
I understand. All right, be admitted.
I have no further questions. Ms. Riedel's going to have some questions for you.
All right, Ms. Riedel, cross-examination.
Yes, sir. Ms. Mobley, you say that you hated to bring this action, that it was caused problems in the family. That's what you testified to.
That it would cause problems with the family.
That it was hard for you to bring this action against your niece.
Oh, yes.
But you brought this same action or very similar action in 2021, did you not? And in that time, you were awarded visitation, were you not?
That's right.
By agreement, correct?
Yes, ma'am.
And you get to see these children once a month, correct?
That's correct.
Now, your side of the family could certainly see these children while you have them in your custody, could they not?
Yes, ma'am.
Okay, so there's no reason for most of these folks not to have seen them for the last 4 or 5 years because, or well, let's just talk from 2022,
Right.
because you've had visitation every single month, correct?
That's correct.
Okay. Now, you stated that that my client was evicted, correct? That's what you stated?
And that's what I was under the impression of. Yes, ma'am.
Okay, and isn't it true it was because repairs had to be made on the house?
Which house are you talking about? Which one?
Well, which house do you think she was evicted from?
She was evicted from her grandma's house,
Well,
her mother's house.
okay, and when was that?
That was in April of 24.
Okay, and isn't there problems? There's always been problems between her and her grandmother and mother, correct? Off and on, there's always been problems, right?
That I
You're
don't-
aware of those, correct?
Sometimes, yes.
Yes. Okay. And as far as the documents that you gave us here today, there was an eviction or they were asked to move because of that there had to be repairs made on the house, correct?
And the repairs were not made right.
Okay. All right. Now there was, you said that BB had low test scores, correct?
Well, in the 70s.
Okay. And she has an IEP. Isn't that correct?
Just for speech is what they told me. I met Friday with her teachers.
But she has an IEP.
That's correct.
That they're working with her.
That's correct.
Okay. And you also stated that you've put Ty into counseling, correct?
That's correct.
Now, the reason that Ty might need counseling, he is very unhappy. He was very unhappy about being put in your home, is he not?
I'm sure he has. He hadn't seen me in 4 years. He is very unhappy.
Okay, and he didn't want to be there, correct?
You're right.
And he still doesn't want to be there. He wants to go home with his mama, doesn't he?
You're probably right.
And as a matter of fact, after the visitation, even CASA has said the children want to be returned to their mother,
Your
correct?
object, she's listing hearsay
That
testimony.
is true, Your Honor. I'll rephrase. But you're aware that the children want to go home,
I'm not aware that the little two want to go home. Absolutely not.
okay? They're not afraid of their mother, are they?
Your Honor, I object. She's
From your
listing hearsay and calling for speculation.
Your Honor, I'm going to I'll rephrase that question. I think she may be right the way I ask it. Did you take the children to CASA?
I did.
Okay, and the children, from their demeanor, they were not afraid to go to their mother, were they?
Two of them were ready to get out, and one of them was not.
Okay, but they were not afraid to be, from their demeanor, they were not concerned. They didn't seem afraid to be with their mother, did they?
They weren't afraid to be with their mother, no.
Okay. Now, the children, you showed this one picture of I believe it's little boy's bottom,
It
correct?
was a little boy's bottom.
And that is the only evidence that you have of any kind of physical punishment or what you believe is physical punishment, right?
That was not.
Okay, that's the only picture that I've been provided. Isn't that true?
That's the first one that I can tell was a good beating yet.
Okay, and you believe that was a beating?
Yes, ma'am.
But you have no idea how those marks got on that child's bottom, do you?
No, I don't.
Okay. And the marks were, even if it was a spanking, the marks were solely on the child's bottom, were they not?
No, there was one on the leg.
Well, you just showed pictures of the bottom, correct?
No, I showed a picture of the leg too. It's there.
Okay, all right. Right at the top of the leg, is that what you're talking about?
Yes.
Okay.
And I do know that Paxton said that Mama, Daddy done
Well,
it.
Your Honor, I have not asked for hearsay testimony.
I agree. I'm not going to consider over an objection. I won't consider hearsay.
Okay, you stated that DFAX was called.
From my knowledge, they were.
Well, isn't it true that you know good and well they were called? They were called by Robin Floyd, were they not?
You have to ask Miss Robin that.
Well, and Miss Robin comes to your house, doesn't she?
Yeah, she comes and sees her granddaughter.
Okay, and you were aware that Miss Floyd called DFAX, were you not?
Was I aware that she called him?
Yes.
I was made aware that she did.
Okay. And I believe in your petition, you said that DFAX was called twice. I believe that's what you said in your petition, but isn't it true that both times, both this time and the previous time, DFAX didn't even open a case? They just closed the case.
I have no idea what they done.
Okay. And isn't it true that you've really been trying to get these kids ever since since before 2022?
I tried to get them on my one weekend. I have not tried to get them. No, ma'am.
Okay, now you said that the kids' demeanor has changed. It's calmed down since you've had them over time.
Yes.
Okay, kids weren't very happy about being taken away from their mother, were they?
They never shed a tear.
Mm-hmm. But you are aware that they were not happy that they were taken from their
That
mother.
was savage.
I never seen them upset.
Okay. One moment, please. I have nothing further. Thank you.
All right, you can step down, Ms. Mobley. All right, that's the two. So, Ms. Riddle, are you ready?
Your Honor, I would just ask that the court consider that there has not been enough evidence submitted at this point. From the plaintiff's testimony, the standard for a third party to get custody of a child or children is very high. It is clear and convincing evidence. And We don't have any clear and convincing evidence that these children have been harmed in any way. We've got a picture of a child who, even if it was from a spanking, it's on the buttocks and upper leg. You will hear testimony that's not what it's from, but however, even if it were, even considering what they believe, and I believe that the standard of clear and convincing has not been met for either third-party custody or the equitable caregiver. Matter of fact, I don't think there's been any testimony today that would even come close to stating that they are an equitable caregiver, because for an equitable caregiver, the law is that they have to be held out as parents. And there has not been even one shred of testimony regarding that these children looked at these folks as at Miss Mobley as a parent.
Well, I'm going to reserve ruling on that for now. I want to hear what you got to say, Ms. Riedel. So call your first witness.
I call, one moment, Your Honor. I call Becky Cawley.
Okay.
I asked her to step outside.
Oh.
Oh, I hope Becky's
Come on up here,
accent
ma'am.
is thicker. It's really, really more thin.
Up on the witness.
Oh, I'm sorry.
stand.
Your Honor, I object to her taking anything to the stand.
Your Honor, I'm fine with that being put aside.
Okay. Well, you'll get a chance to see it, Ms. Kirkland. All right, Ms. Riedel, you can swear her in and proceed.
Would you raise your right hand, please, Ms. Cawley? Do you swear or affirm the testimony you're about to give before this court is the truth, nothing but the truth, so help you God?
I do.
Okay, and you can put your hand down. And would you state your name, please?
Nancy Rebecca Cawley, but I go by Becky.
And your last name, would you spell your last name, please?
Cauley.
And what did you do, Ms. Cawley?
I own a Helping Hands thrift shop.
And how did you know Ms. Phillips?
Paige used to, has a child with my son, and Ty is 14 and a half, it's to be 15. And she's been a part of our family for 10 years now.
And just to get this out of the way, your son is in prison, correct?
That's correct.
Now, have you maintained a relationship with Ms. Phillips?
Dad's in prison. Now we know.
Yes, I have.
We are
She's like a daughter
shocked.
to me.
How often do you see her?
Several times a month, and up until recently, just about every day. She worked with me at my thrift shop off and on for the last 3 years.
Okay, and have you had the opportunity to see her with her children?
Many, many times.
Have you ever seen the children being concerned to be around her from your observation of their demeanor?
No, ma'am. Paige can't get 3 steps away from her kids. Where's mama? Where's mama?
You can't say what the children say, but,
Okay.
and if you will, if you can talk a little bit from your observation, what is their relationship like? What's their bond like between mom and the children?
And they love their mama to death. When Paige walks out of a room, they go find her. If she has to go outside to the car or something, they're running after her. If we go on the back porch, they're 2 steps behind. When they're out in the yard playing, they'll play for a few minutes and they'll run up there to the mama, give her a hug and a kiss, and then run back and go play.
Have you ever noticed, do you know her husband?
I do.
And how long have you known him?
Since they started dating, I think they got married June last year, so a few months before that.
Okay, and from your observation of the children with him, how did the children, from your observation, what is the children's demeanor in his presence?
Pretty much the same as with Paige. I know several times Paxton would be asleep and Tony towed him in the house. And I've seen him outside playing in the yard. I've seen him playing on the trampoline at our house. We've went out to eat. Tony's went and helped Paxton fix a plate. I mean, they look to him, and Ty does too. I mean, I've seen Ty playing with Tony.
Have you ever seen, have you ever seen her husband be in any way aggressive toward the children from what you personally have observed?
No, I haven't.
Have you ever noticed the children seeming, from their demeanor, seeming to be afraid of him in any way?
No.
Now, I want to kind of shift the focus a little bit directly to Ty, who is your grandson, correct?
That's correct.
What's your relationship like with, what's your relationship like with Ty?
It's very good. He calls me all the time, just for no reason at all. Just say, "Hey, Nana, what you doing?" He texts us at night, "Good night, I love you." We love him. I mean, he's our grandson, and we have a very good relationship. He can come to me and talk to me about anything.
Now, what about his relationship with his mom?
When he's at our house and Paige is not there, he'll call her 3 or 4 times and say, "What are you doing?"
Okay, but don't say what he says.
Just for no reason at all.
Now, did your grandson have some, are there any medical issues with your grandson?
He has Tourette's.
And when Tourette's, when I think of Tourette's, I think of the classic where they use curse words and things like that. Is that the sort of,
No.
Is that the kind of Tourette's that he has?
No, he has little tics like this, or clearing his throat, the eye blinking. But he's actually starting to grow out of it. When he's at our house, he hardly ever has tics anymore. Over the last year, he might have 1 or 2, but we really don't even notice him having a tic at all anymore.
Now, what's his relationship like with his younger siblings?
They're brothers and sisters. I mean, they act like brothers and sisters. I mean, they play together. Ty, he'll play in the pool with them. He'll take and he'll throw them, and they'll run back, throw me again. I mean.
Okay. Is he, or have you ever observed him taking care of the children?
Yes, I have. He takes care of them even when the adults are around. He's always taking care of them.
Okay. And do the smaller children listen to him when he directs them?
Yes.
Okay. How does Ty do in school?
He's in gifted classes and honor roll. I'm super proud of him. He's very smart.
Have you ever, and I don't know the answer to this, which might be something I shouldn't say, but have you ever observed Paige doing homework with any of the children, or helping them with any of their schoolwork?
Yes, I have.
Okay, and tell us what she does.
For instance, one time, we have cement front porch and cement back porch, and we have several boxes of sidewalk chalk. And when BB was learning her ABCs and 1, 2, 3s, Paige was down there on the floor helping her write her numbers, say her numbers, her letters. And BB's got several notebooks, I know, where her and her mama sit there and practice and play,
Now, are you aware of any issues that Paxton has?
Yes, he has hearing issues.
And are you aware of what if anything, Paige has done to try to help him with that issue?
Yes, I am. She has taken him to several doctors, and me and her have had many, many conversations about it, and about the doctors not wanting to do anything.
Your Honor, I object. That's hearsay.
I agree.
Okay. Well, they give him a hearing test and he fails. And they say bring him back in 3 months. And she's had to fight with him to get tubes put back in his ears.
just to remind you, hearsay means you can't say anything that anybody says, okay? Except what Ms. Page says.
Okay.
Okay, do you know whether or not he's had, any kind of operations or anything like that?
Yes, he has.
And what is that?
He had tubes put back in his ears.
Do you, from your pretty constant observations of Paige with her children, do you have any concerns regarding her care of any of the children?
I do not.
Now, do you have any concerns about her husband's care of the children from what you have observed?
I do not.
I know you said you've seen her several times, several times a month. Do you see her husband often, or how often do you see him?
Not as often, but usually about 3 or 4 times a month.
And are the children around when you see him?
Yes.
And any concerns?
No.
Okay, I don't have anything further.
Just because children love their mother doesn't necessarily mean that they're a great parent, does it?
No.
Okay. You said you were very proud of Ty in school, correct?
I am.
Were you aware that for the 24-25 school year, he missed 18 days of school?
I am.
And you were aware that he missed 10 days alone in the fourth quarter?
I am.
Okay.
And he still made a high honor roll in gifted classes.
Can you imagine how he would have been if he'd actually gotten to go to school when he was supposed to?
Probably the same.
Okay. Now, this is the 10 absences were after she had moved them to Dodge County, correct?
Probably. I don't know.
Now, how many different addresses have these children had since February 2022?
4.
Okay. All right. Are you aware that they lived at 1690 West Highway 280, Apartment A in Milan,
I am.
Georgia? That was February 2022, correct?
That's correct. She paid a whole year's worth of rent
Okay.
at one time.
And then in April of 2022, she moved to 69 Shady Lane in McRae, correct?
Yes, to Uncle Ken's house that had passed away,
Okay.
that
And
she was
then-
supposed to inherit.
All right. And then in February of 2024, she moved to 19 Misty Lane in McRae, correct?
Yes,
Okay. Then in August of 2024, she moved to Donnie Lane Apartments in Baxley, correct?
yes,
Moved the children from Telfair to Appling County Schools, correct?
yes, but not during the school year.
Okay. And then in January 2025, they moved out of Donnie Lane, correct?
That is correct.
And they moved to Hazelhurst to 119 South Tallahassee Street, correct?
That is correct.
And kids stayed in Appling County Schools with her driving them back and
That is correct. And she worked with me at my store when she took the kids to school. Instead of driving back to Hazelhurst, she worked with me at the store till it was time to get the kids from school. And then she'd get the kids from school and go home.
Okay, and she was evicted from South Tallahassee Street in Hazelhurst, correct?
Technically, but the plumbing was the issue. From the very first week that they moved in there, there was poop water coming up. The bathtub was overflowing. We have pictures and texts, and
Not a
they
fit
would
environment.
not
for
a
children.
very
But how though? How do you move 6 times that quickly? Because you got to have the first month, the last month, security deposit. How did that happen? It would take me a year to come up with first month, last month security deposit. And she's moved 6 times?
very good environment. And we looked and looked for her from the minute they moved in there for something else to live. And just this place here was the closest they could find.
Then they moved to 67 Fountain Road
Yes,
and stayed in Appling County Schools despite the probably almost hour-long
that's
drive,
correct.
correct?
That's
Okay.
correct. She did not want to interrupt their school year.
So that's actually 6 addresses since February of 2022, isn't it?
Mm-hmm.
And that's 4 addresses since February of 2024,
That's correct.
correct? 18 months,
Mm-hmm.
4 addresses. Do you think that's good for children?
I don't see where it's hurt the kids any at all.
Okay. Do you think that's normal?
When you're looking for a better place to live that doesn't have problems, yeah, I would move too.
All right.
I'm not going to stay there with poop water coming up in my bathroom. No, it's not going to happen.
All right. So where they were living was not fit for the children?
The house was fine, but the toilets was not.
Okay. Now, you talked at length about her taking Paxton to the ENT, correct?
That's correct.
You're aware that Paxton missed at least 3 appointments with the ENT from between 2023 to March of 2025?
No, it's not.
Okay. Would you be upset if that was your grandchild who needed to go to the ENT and mama kept missing appointments?
It's according to why the appointments was missed and what they were going to do. And if she called to reschedule the appointment. But no, I don't think so.
Let's talk about Mr. Melton. When did you meet him?
When?
Yes, ma'am.
A couple of months before they got married. They got married in June. So was
Okay.
it around April, May?
April, May of what year?
Dude, 20, they got married 24. I guess 24.
Okay. Now, how long did
Maybe
they date
23.
before they got married? Are you aware of that?
Several months.
Okay. All right. Did she have any boyfriends prior to that?
And 5 or 6 years I've known her, she dated one person for a month or so, and she was like, no.
Okay. Well, let's talk about that. You say you've known her 5 or 6 years.
Mm-hmm.
Your grandchild's almost 15, correct?
Yep.
Okay. What kind of relationship did y'all have the first 10 years of your grandchild's life?
I did not see him until he was like 4 or 5 months old.
Okay.
And we was in his life for a little while then, but I think she moved somewhere. Anyway, not as close as it's been in the last 10 years.
Okay. So it's a consistent pattern of in and out, right?
No, I wouldn't say it's consistent.
But you didn't get to see Ty till he was several months old, correct?
No, I didn't see him till he was several months old. And I
Okay.
saw him, he was probably about 2 years old, 2 or 3.
Okay.
But we didn't see him a lot.
All
We didn't,
right.
I mean,
And then there for a while, you got to have regular interaction with him, correct?
yes.
And then at another point, she met another man or moved somewhere, and you didn't get to see him for a while, correct?
I think she moved out of town, yeah.
And then over the last 5 years or so, you've seen him pretty consistently.
The last 7 years, yes.
Okay. Would you say that's a pattern of letting you see him, not letting you see him? Depending on who she's married to, what she's up to.
No, there's more circumstances than that.
Now, did you discuss,
Sorry, drink.
let me rephrase that. Are you aware of Mr. Melton's criminal history?
Somewhat, yes.
Okay. Were you aware that he was convicted of burglary in Appling County?
Nope,
Were you aware that he was convicted of aggravated battery in Appling County
yes,
and that he went to prison for that?
yes.
Okay. Were you aware that he was arrested and charged in Bradford County, Florida for lewd and lascivious behavior against a child less than 12 years
And
old?
from my understanding, that was dismissed.
Okay. You understand he was arrested for that?
Yeah, you can be arrested for anything.
You have no problem with a
I do.
man who's been accused of what would be child molestation in the state of Georgia, being around your grandson and his little half-sister.
No, because if you know the story, then no, I do not.
Do you know
There's
the
a story to everything.
Do you know the story?
Yes, I do.
Okay, whose side of it do you know?
Yes.
Your Honor, I'm going to object to this because
And this is hearsay.
Wait a minute. Wait.
I have her on cross, Your Honor. I'm entitled to a thorough and sifting
Well, you are,
cross-examination.
but you're going to run out of time, and we're going to conclude this hearing, and you'll get another court date in about the 12th of February. So
All right.
you've got to get back to the
I
point.
will, Your Honor.
All right, but no,
Okay.
I'm not finished, because I understand this is turning into a deposition. You're going to have plenty of time to do that. But I'm telling you, I'm going to get up and walk out of here in a few minutes because I got more to do, and you can wait.
All right, Your Honor. Did you bother to check in to the other side of the story prior to deciding?
No.
Okay. Nothing further.
All right, Ms. Riddle, anything else?
No, Your Honor.
May this witness be excused
Yes.
for today, of course. All right, Ms. Colley, thank you for your time. You are excused for today. You may go about your business, but you're welcome to stay if you want to, but you can leave. All right, who's next, Ms. Riddle?
Paige Phillips.
All right, Ms. Phillips, come on up here. Before I forget it, did I sign an order for a CASA to be the guardian ad litem and do a home evaluation? Because I don't,
Yes.
okay, just making sure. I don't remember if I got anything on it or not, but I'm sure you'll tell me when the time is right. But, all right, you can swear her in and proceed.
Would you raise your right hand, please?
Hold on. I don't see the order in the file. That's why I'm asking.
I don't believe it was ever signed, Your Honor.
It might not have been signed.
Okay.
I know you asked for it. I don't know what happened to the order.
I don't either, but I've emailed Gwen and Brooke to have them kind of run it down or track it down. Bart, you can swear her in and proceed.
Do you swear from the testimony you're about to give before this court is the truth and nothing but the truth, so help you God?
I do.
You speak very softly. Please try to speak up and speak into the microphone. State your name, please.
Paige Phillips Melton.
And Ms. Melton,
Yes, ma'am.
when did you get married?
June 20th of 2023.
And how long did you know Mr. Melton prior to marriage?
Shortly after the first case,
Okay, and that first case ended in 2022, or when did?
2022.
Okay. And since you and Mr. Melton have been married, have there been any concerns that you have had regarding his relationship with your 3 children?
No, ma'am.
Have there been any times when he has harmed them in any way?
No, ma'am.
Okay. And you're aware of all the things that went on, the allegations and whatnot in Florida,
Yes, ma'am.
and there's not been any concerns?
No, ma'am. None at all.
Okay. Now, have you taken, I believe is it Paxton that has the ear problems?
Yes, ma'am.
Have you taken Paxton to have his ears seen about?
Yes, ma'am. He has 2 set of tubes, and he recently just got his adenoids and tonsils and a new set of tubes.
Okay. And when you, did he have several doctor's appointments?
Yes, ma'am.
And were there some appointments that were missed or rescheduled?
Yes, ma'am. They were
And-
always rescheduled.
Okay, and why were appointments, do you recall why any appointments were missed?
Sometimes they would be because of the insurance problems there, and then sometimes it would be because like either one of the other kids was sick or we just couldn't that day.
Did you, does your child have insurance?
Yes, ma'am.
And what was the problem with the insurance?
I just had to renew it.
All right, now, you've moved several times in the last few years. Did the children have proper housing?
Yes, ma'am.
Now, what was the situation where the plumbing went bad?
Uh,
Let me ask it a different way so we can kind of snap through this.
Yes,
Was the plumbing bad when you moved in, when you went to look at the house?
not that we recall at first, but when we started actually taking baths and stuff like that, that's when we noticed the feces in the water in the bathtub.
Okay, and as soon as you learned about that, what did you start to do?
I immediately called the people so they can come fix it.
Okay, and was there problems trying to get it fixed?
Yes, ma'am.
Okay, now there was other moves as well. Let's talk about where were you living when you first, when the 2022 case was finalized?
In Milan at the apartments.
Okay, and how long were you there after the 2022 case?
Well, I paid for a whole year to live there. So a year and a little bit after that. And then we shortly moved to 69 Shady Lane.
Okay, and was that also in Telfair?
Yes, ma'am.
Okay, and did the children go to Telfair both, when you were living in those two locations?
Hmm.
Okay, let's say yes or no.
Yes, ma'am.
Okay. And, after that residence, where did you move?
We moved to 19 Misty Lane.
And what was the reason for that move?
We got a job opportunity in Baxley at Apple Lane Apartments.
And, how long did you stay there?
Mm,
Approximately. I don't expect it to be to the day, but approximately how long?
about it was around the like May or something like that. I'm not really.
And when you moved, where did you move to next?
To Hazers.
Okay, and why did you move to Hazelhurst?
Because some
I know you're nervous, but we need to try to get through this because the court's already told us he's ready to leave. I mean, he only gave us so much time is what I mean by that.
Yes, ma'am. I'm
So,
sorry.
do you recall why you moved to there?
Moved to Hazers.
Yes, ma'am.
Because there was something about some tools or something like that, but we didn't.
Was there a problem with the employment at the last place?
Yes,
There was a
ma'am.
dispute there?
Yes, ma'am.
Okay, and then you moved to Hazelhurst. Did you have employment there?
No, ma'am.
Okay, and how long did you live in Hazelhurst?
I'm not really sure how long, but like we did.
Were you working with Miss Becky during that period of time?
Yes, ma'am.
Okay, and did you move from Hazelhurst to Eastman?
Yes, ma'am.
And why did you move to Eastman?
Because once again, I had another job opportunity here.
Okay, and your husband have a good job here?
Yes, ma'am.
Where is he working?
At Web Swamp Logging.
He makes
where?
about $5,000 a month, is that
Where does he
right?
work?
Web Swamp Logging.
Okay.
Make about $5,000 a month working there.
Yes, sir.
And
Yes,
what are
ma'am.
you doing now?
I'm at work at Eastman Healthcare and Rehab.
Okay, and how long have you been working there?
Right at almost 3 months.
Okay, since you kind of got settled in?
Yes,
here?
ma'am.
Okay, now, when you moved to Eastman, was it about April or something like that, the end of April? Or when did you move?
I think we started living in 67 Fountain Road at like the beginning of April.
Okay, and why did you keep the kids in Hazelhurst in school?
The kids were in Appling County
I'm sorry. Why did you keep them in Appling County?
because they only had a month left of school. There weren't no sense in just enrolling them into a whole different school.
And what was your intention of as far as school this year?
That they would attend Dodge County School.
Are you aware of why there was a picture of your child's bottom? Do you know how your child got that mark on his bottom?
No, man, we really don't spank them because of situations like this.
Okay, and what do you mean by situations like this?
Like situations like, just like the last course case of.
Allegations?
Yes, ma'am.
Okay, and do you know, do you know whether he failed? Do you have any idea?
When that youngin plays outside, he gets more bruises and scrapes than anything.
Now, BB was repeating the first grade. Would that be a fair thing to say?
Yes, ma'am.
And why did you make the decision, or why was the decision made for her to repeat first grade?
It was in her best interest.
Okay. And was she, what kind of IEP program is she in?
Well, it's for speech, and then also like she'll have some testing and stuff, like
Okay.
a longer time with testing.
Does the IEP, is it helping her in any way?
Yes, ma'am, it has, and she's also has or had at Appleton County. She had a reading tutor and a math tutor as well.
Now, have you checked to see what kind of availability it is in Dodge County for your child?
Yes, ma'am.
And is there programming available here
Yes, ma'am, there is.
or in Dodge County? As far as Paxton,
Yes, ma'am.
who has hearing problems,
Yes,
tell
ma'am.
us has he gone to ENT doctor?
Yes, ma'am.
And how often does he go to an ENT? How often did he go to an ENT doctor when you were with him, when he was with you?
Every 3 months.
Okay, and did you follow the recommendations of the ENT doctor?
I did.
What kind of help was Paxton getting as far as speech?
He was getting speech therapy in school for 30 minutes, and then before he even started school, he was also in Harrison speech therapy before he started school.
Okay, and how often was he getting therapy in school? Do you know?
With school or Harrison?
With school,
Well, I'm not,
daily or how often?
sometimes daily, and then sometimes it'll be like 2 weeks, and then,
Did that seem to help him?
yes, ma'am.
Now, are you familiar with the incident in which your husband was arrested recently? In May, I believe it's the booking. Are you familiar with that?
Yes, ma'am.
What happened in that? Well, first of all, were you there when this happened?
Yes, ma'am.
And who called the police?
I did.
And at whose request?
My husband's.
What happened?
We were checking out in Harvey's, and this gentleman that we didn't even know at all, he was pushing our watermelon, and well, COVID's going around and stuff like that, and we were about to all eat it at home, and my husband politely asked him to stop, like moving our watermelon, and then we checked out and stuff like that, and then after that, the gentleman asked to speak with my husband, and then it just escalated from there. He wound up throwing a beer bottle at my husband. So,
And were both your husband and this gentleman arrested?
yes, ma'am.
Okay. Has anything come up in court about that yet?
No, ma'am, not yet.
DFAX has been called to your home previously.
Yes, ma'am.
Has DFAX ever opened and kept open a case on you?
No, ma'am, not at all.
When did the DFAX come the first time?
Um,
Approximately.
like 2024, 6/2024.
Okay, and was a case opened up at that point?
It was, but it was shut after 9 days.
Okay, and do you know what the allegations were that time?
Some of them were that they were mistreated, and then some said something about that they had. I'm not really sure. I don't remember all the allegations on that one.
All right, and was the DFAX called back again this year?
Yes, ma'am.
And what happened at that point in time? Have they opened up a case this time?
They did, but also the kids was with Lucretia that first week for her week visitation. So therefore they went to her house to see with all that.
Okay, and did they close the case?
Yes, ma'am.
I don't have anything further because I think we're running out of time. I'll probably already run out.
Very
Well, we have-
I'll be
Very quick, go ahead.
All right, who is Diane Wisham?
My grandmother.
Okay, and are you aware that she took a TPO against Tony Melton?
Yes.
Okay, I'm gonna tender that as plaintiff 16,
No objection, Your Honor, to that.
certified copy.
Admitted.
Okay, and your grandma took a TPO against your husband, correct?
Yes.
Okay, and the 6 moves that you've made since February 2022. All right. The Donnie Lane apartments, y'all were supposed to be doing the maintenance. You were moved into the maintenance apartment, correct?
Yes.
And you were asked to leave because you did not do the maintenance work, correct?
No.
Okay. You were served on the Tallahassee Street address, you were served with a letter by the owners that you were past due on rent, correct? In April of 2025, you were served with a letter asking you to pay the rent or legal action would be taken, correct?
Yes.
Okay. And then how long has your husband how long has he worked for Web Swamp Login?
2 years.
Okay. And you said y'all moved to Eastman because he had just gotten a job opportunity, correct? Isn't that what you said a few minutes ago?
Well, he's worked off and on with them for 2 years.
Okay. So he's actually worked there 2 years. All right.
Yes.
Now, BB missed 11.64 days of school the last quarter she was in Appling County Schools last school year, correct?
How many days?
11.
Yes.
Okay. You had already received notice from her teacher that she was very likely to be retained, correct?
But not because she missed a lot of days, no.
Okay. You didn't think it'd be important for her to go to school when she was on the brink of being retained?
She did go to school when the kids didn't have doctor's appointments.
Okay. So why did she miss 11 days of school in the last quarter of the school year?
Because that's when a lot of their doctor's appointments was.
Okay. So she missed even if it wasn't her doctor's appointment,
Yes.
even though she was about to be retained and you had requested a conference with a teacher. You didn't think it was important for her to go to school.
There was a bunch of conferences with the teachers before that.
Okay. My question is, you didn't think it was important when she's on the brink of failing for her to go to school every single day that she could?
Yes, it is important.
Okay, but she still missed 11 days in a short period of time, correct?
Yeah.
Okay, Ty missed 18 days last school year. He missed 10 in the last quarter, correct?
Mm-hmm.
Okay, why? Why did he miss 10 days of school? You just didn't want to get up and take him? What was the deal?
No, I take them when they need to go to school.
When they
But
need
they
to go to
also
school?
go.
So you'd get up every day and decide whether or not your children need to go to
No,
school?
I don't. They go to school when they go to school.
Okay, so it's just whatever's going on that day, if school,
No, that's not what, no.
then
that's
why
not
did your
what's
child
happening
miss
at all.
10 days in one quarter? You don't have a good answer for it, do you?
They only miss school when they had doctor's appointments.
Okay,
And it's only half a day.
all right. But
But it winds up counting as one day if they miss more than one.
Okay. Do you think it's normal to move children 6 times
Within
in
the
3.5
circumstances,
years?
within the circumstances that was happening to us, yes.
You think it's normal to move 4 times in 18 months?
In 18 months.
Yes, ma'am.
If you knew that under the circumstances that we were in, yeah, you would move your kids too.
Okay, well, what were the circumstances? Your husband's already working for this place where he's supposedly making $5,000 a month, correct?
Mm-hmm.
Why were y'all in these circumstances if he's working a job where he makes $5,000 a month? Why were you evicted or why did you receive a letter for not paying your rent at $800 a month in Hazelhurst if your husband's working this good, steady job?
I'm not sure.
Okay. Where was your money going?
Okay, I didn't know until right now. It's drugs. It has to be drugs. It has to be drugs. Even the way she's talking right now has me suspicious. Oh, there you go. Yep, telling us the same way. I think she's on drugs.
We have bills to pay. including rent, and we eventually paid the rent.
Eventually. Rent wasn't number one on
Yeah,
the
with the
list.
electric and all the other bills that
Okay.
you're supposed to
All
pay.
right. In the hierarchy, in the scheme of things, wouldn't be keeping a roof over the children's head kind of be at the top of the list?
Yes, we made sure that every time.
Okay. And so you dodged the eviction on Tallahassee Street by going ahead and moving to Eastman, correct?
Hmm. And we had jobs there.
Okay. Instead of catching up the rent, you chose to move them an hour away from the school system they were in, correct?
Would you allow your kids to bathe in feces? Because I'm not.
Okay. And again, you were served a letter about non-payment, correct?
Yeah.
How many bedrooms do you currently have in this house on Fountain Road?
2,
How many bathrooms?
1,
Where did the children, when they were with you, where did they sleep?
and their bunk beds in their bed.
Okay. In what rooms? Ty actually sleeps in the living room, correct?
Yes.
Okay. And the 2 little children share the other bedroom, correct?
Yes.
So you do not even have beds for all the children, correct?
They all 3 have beds.
All right. Is there a bed in the living room
Yes.
or is it a pull out?
It's a bed in the living room.
Okay. So on your financial affidavit, you state that you make $2,166 a month, correct?
Mm-hmm.
And your husband, you stated, makes $5,000 a month, correct?
Mm-hmm.
So that's over $7,000 a month coming in, correct?
Mm-hmm.
And you cannot find a more appropriate place to live with $7,200 a month income.
No, it's hard to rent around here.
Okay. Have you already had a late fee with Plains on this, Plains Investments with this 67 Fountain Road address?
Not that I recall.
Okay. All right. And I'm gonna ask you this. Were you aware of your husband's criminal history when you married him?
Yes.
And you had no concerns about that?
If it's hearsay, then it don't matter.
Okay. You weren't concerned about his convictions?
Mm-hmm.
You were not?
Not all of them, no.
Okay. And when did y'all start dating?
Around the end of 2022.
Okay. So y'all were dating then when a report was made in Appling County by a woman claiming he sexually assaulted her, correct?
Your Honor, well,
I-
never mind, she's got him on.
Were you aware of that?
That's hearsay.
Okay. But you're aware a report was made, correct?
Yes.
While y'all were dating?
Yes.
Okay, and you married him anyway?
Yes.
And that's the second time he's been accused of a sexual crime, correct?
Yes.
Okay, nothing further.
All right, you can step down, Ms. Phillips. All right, this has gone on long enough. I got to stop. As I've said in all the other cases, I'm not going to just shoot from the hip. I got a lot to consider, but I do want to say a couple of things. There's a lot of issues that are going to have to be fleshed out. I understand that. But regardless of how I rule today, I want both sides to understand this is a temporary hearing. Regardless of what happens or doesn't happen today or in the ruling, will have no effect whatsoever on the final day, final hearing. So I just want to make sure everybody understands that. Now, you're Ms. Staples, right? Okay, now is Casas, are you staying involved in this case? Yeah, I do. Absolutely. Absolutely. And I'll have more instructions coming on that. So, all right, that's going to be it for today, folks. I have got to step down. So you're here. If you're here from Mobley v. Phillips, you are excused, and we'll go from there. All right, we'll be back in 30 minutes.
Gee, I wonder. I just can't believe I have no idea who's going to win custody at this moment in time of these kids. The 14-year-old is tough. 14-year-old just wants to go back to mom. That one's tough. But I don't think the 14-year-old gets to pick. I mean, he can run away. You know what I mean? But I don't think he gets to pick. Real quick before I end, I want to thank the parole board for their diligent work and allowing me to be home with my family when the decision came out as a family. We're pleased with the ruling. Yep, this guy right here lost. Ralph lost. So he's set to be executed on September 5th. September 5th. Yes, September 5th. Now, he has one more shot in the Supreme Court that he's going to lose because there are no legal grounds for them to overturn this ruling. I didn't wait, Josh. I said it at the beginning, too. But there was only 10 people here. There was only 10 people here. Oh, man. All right. So that's it. I always watch this court. I always watch this docket. So do not worry about catching the next one of this series. I will be able to. We need to pick a name so we remember. Like there was the mason jar for the other custody battle that we're watching. We need a name for this one. We don't rush it. But try to maybe leave a comment or talk in Discord or pick a name for this saga right here so that we remember it. All right. OJ is late, so I got to get moving. People are going to start calling my phone. Where's my OJ? Thanks for coming out today, guys. I appreciate it so much. I'll see you again real soon, okay? Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. no